Yes,
Yes, sir.
Yes, please.
yes. So a very good afternoon to all the viewers. Myself, Dr. Rajesh Singh, and today's webinar is on the topic of hypothesis testing in the legal research and empirical approach. And today we have with us Dr. Surya Prakash Rao, Honorable Vice Chancellor, Damodaram Sanjivayya National Law University. So first I will go to the profile of Professor Surya Prakash Rao. I will not take more time. So, so as per his resume, Mr. Surya Prakash Rao assumed the charge as a Vice Chancellor of DSNLU on 19th October 2023. Previously, he was a visiting professor in the law at the Maharashtra National Law University. He served as a prestigious, just a minute. He served as a prestigious professor in the National Law University, and he has done the he has worked in the Dr. B.R. Ambedkar College of Law, Andhra Pradesh University, in different capacities such as principal, chairman, faculty of law, chairman, board of studies in law, convener, research forum, student advisor, deputy warden, and dean guest house of Andhra Pradesh also. Further, he was also the recipient of the Andhra Pradesh State Best Teacher Award in 2016 and Best Research Award of Andhra Pradesh University in 2007, and Dr. Sarvapalli Radhakrishnan Best Teacher Award of Andhra Pradesh in 2009. He is a rare combination of academics, research, and administration. He is one of the senior professor who has served the university with 40 years teaching experience, including 80 years of the professor of law. His area of specialization are wide, including the jurisprudence, constitutional law of India, human rights, family law, criminal law, and commercial law. He published more than 60 articles in reputed law journals and one book. He has participated and presented papers in more than 250 national and international seminar and conferences. Under him, more than 50 students have completed the PhD degree, and still 30 students are doing PhD under him. So not taking more time, uh, I'm very much thankful. And today we have Dr. Bijal Javeri, Academic Dean of the Doctoral Studies, who will welcome Professor Surya Prakash Rao, Vice Chancellor of National Law University. Over to you, ma'am.
Yes, thank you so much, sir. First of all, we welcome Professor Surya Prakash Rao, Vice Chancellor from National Law University, myself, Dr. Vijal Javeri, Academic Affairs Associate Dean, and from Doctoral Studies and Research. And on behalf of our Dean, Dr. Purvisha, from Doctoral Studies and Research Department, we welcome sir for this wonderful session. This is a really a great webinar series we are arranging for the students, those who are making their career in the research journey. And it would be a really a great opportunity to learn from the experts, those who are in the field such a long tenure. So today's session for the topic, that is a hypothesis testing. It is like assumption to assertion. So how we can use a hypothesis testing technique in the legal research, that will be specific insights will be delivered by our Professor Surya Prakash Rao sir. Whatever the question answer sessions we are having along with us, moderators Dr. Ashwin Kumar and Dr. Rajesh Singh sir, coordinated from Law Department. So I would request that once, if they are after this session also, if students is having any query, you can collect the questions in the chat box, so we can share at the end of the sessions. And we are very grateful to the law faculty of law for organizing session in joint collaborations with Doctoral Studies and Research. So thank you so much. We would like to hand over the platform to our today's speaker, and we can start the session. Thank you, sir.
Yes, sir, you can start now.
Shall I start?
Yes, sir. Yes, sir, you can start.
Okay. So, very good morning. I deem it a privilege to associate myself with the research program of Parul University, Vadodara. So I am happy that I have been associated with this university for the last 2 years, uh, and I physically visited university uh, twice, and recently also regarding this moot court competition. Uh, I I had a direct experience with the university,
Hello.
and I appreciate the infrastructure and academics and research of Parul University. And as I was invited to speak on hypothesis testing in legal research and empirical approach. So for this matter, recently we had a good literature, particularly Professor Ishwar Bhatt wrote a comprehensive book uh, on legal research, which is very useful to research scholars. And as we know, law is a normative science. Law is a normative science. And until 1980, actually, what are the fundamental issues to be answered in the legal process? What is law? What is the function of law? And what is the end of law? If you go to answer the first question, what is law? Law is an experimental science as far as Roscoe Pond is concerned. So, in the initial stage, the law is understood as a dictate of God, dictate of nature. And by 19th century, Immanuel Kant refined the uh, idea of this reasoning. Law is a categorical imperative. Law is dictate of reason. So, Immanuel Kant is the last protector of natural thought, where implanting the study of law in the light of reason. Law is dictate of reason. So the neo-Kantians, the modern followers of Kant, particularly John Rawls, who had developed the concept of reflexive equilibrium, and law should be understood in the light of equality and liberty. One can achieve justice through the concept of equality. Equality is a means to achieve justice in social democracy. Liberty is a means to achieve justice in liberal democracy. And Amartya Sen understands law, the justice is a removal of inequality in the society. And Martha also developed an idea improving human capabilities in order to uh, enjoy and enforce human rights. The fundamental human capabilities have to be improved. So, in order to understand legal research, one should understand what is law, what is the function of law, and what is the end of law. Then the question of coming understanding research. What is research? Research is nothing but knowing more and more about less and less. So you take a word liberty. So if you start research in understanding the concept of liberty, you can deeply involved in the research. If you go to understand the concept of justice, concept of equality, dynamics of equality. So the more you understand, the more you can have exploration of the journey of knowledge. So here, that's why, as you know, the natural thought basically understands law is dictate of God, dictate of nature. Then ultimately it refined to the stage of law is dictate of reason. If you go to positive law, where you have law is a positus. That is what is law is a sovereign command which has sanction. Law is a command from a political superior to political inferior. Political superior, a sovereign authority, to political inferior, a sovereign subject. So, of course, 19th century positivists are so rigid in understanding the law, whereas 20th century positivists, particularly 19th century positivists, Jeremy Bentham and John Austin, tried to understand the law. They wanted to decide the boundaries of the jurisprudence, the province of the jurisprudence. Thereby, they excluded all the other elements from the study of law. The 20th century positivists like H.L.A. Hart, who studied law in the light of a system of rules. Law is a combination of primary and secondary rules with some basic concept of recognition. In order to understand, in order to recognize a particular rule as law, one should have to take note of minimum content of morality. So that again leads to the heartful debate regarding the understanding of the scope of law. So 20th century positivists are less positivist comparing to the original true positivists of 19th century. In 20th century, as we all know, in the backdrop of development of sociological studies, law is understood as a functional school, law as it does. So, meanwhile, historical school jurists also developed. In order to understand the legal system at present, in order to understand the law at present, one should go the past. Law is not all of a sudden created. It has its roots in the past. So you take Savigny, who studied law as a volcagist. Law is nothing but nation's spirit. And the same historical Vinogradov and particularly Henry May, who wrote ancient law. So he studied ancient Roman law system, ancient Hindu law system, ancient Greek law system. There, the famous statement of Henry Maine regarding the comparison between Hindu law and Roman law. The failure of Hindu law is the success of Roman law, is the famous observation of Henry Maine. Why he made such observation? At an appropriate time, the law was codified in a progressive society, whether it was Hindu society, Muslim society, or Christian society, or Greek society, or Roman society. But for every reasonable period, maybe 100 years, 200 years, or 500 years, the law is to be recodified. So that's why, in order to understand the different stages of the evolution of law, Henry Maine, another famous quotation, hitherto every progressive society moves from status to contract. Hitherto stage is the codification process. The law should be codified, where legislation plays an important role. So custom is the source for historical jurists, whereas legislation is the main source for uh, positive jurists. So the 20th century phenomena about understanding what is law, law as it does, the functional school. So law keeps on changing with the changing needs of the society as it is part of social reality. Law is part of social reality. So, as far as the functional aspect of law is concerned, law is an experimental social value. So, law is a philosophy. Law as philosophy, law as science, law as a product of history, law as a functional aspect, that an experimented social value. So, in order to start a research, every legal research scholar should know what is this law. Of course, the modern sources of law as everybody understands, custom, legislation, precedent, and juristic works, the opinions of experts and others. So here, in the process of this understanding of what is law, we have to understand all these things. Where we go to understand what is the function of law. So function is the law is an effective agency to bring social control. Law is an agency of social control. Different agencies may be there, but law plays an important role as an agency to control the society. That is the first function of the law. So law was prepared first. Law was brought first. Then people were asked to follow the law. Say, for example, penal law, whether it was Indian Penal Code or Bharatiya Nyaya Samhita, the new criminal legislation, law was made first. People are asked to follow the law. So here, that's why law is an effective agency to control the society. The another important aspect of law is an effective social instrument. Law is an instrument to bring social transformation. Law is an instrument to bring social change. Law is an instrument to have transformative justice. Now, the modern trend is how the transformative justice is achieved through constitutional values, constitutional functioning. So that's why the function of law is twofold. It is an effective agency to control the society. It is an effective instrument to bring social transformation. Then the question comes, what is the end of law? The end of law is justice. Whether justice is corrective justice or distributive justice or social justice or transformative justice, but justice is justice. Justice is a just thing. A research scholar should know all these things. When a research scholar wanted to do some research on a specific topic, identification of the problem is very, very important. Until 1980 in India, there was no such thought of doing research in law. The then lawyers, the then judges, the then legal academicians had strong feeling that every case was a research topic to the judge, to the prosecution, to the defense, or if it is civil, uh, a plaintiff side lawyer and defendant side lawyer and the judge. So every research, every case itself is a research topic. That's why in India, until 1980, there was no real type of research what is going to be carried out in the modern sense nowadays by the research scholars. So in 1980, Indian Law Institute understands, identified that there was a lacuna, there was a lapse in legal research. So as law was the normative science, and maybe the case studies and the precedent, the making of legislative process, all these were might be the subject topics for doctoral study. Whereas first time Indian Law Institute identified some of the areas where all the social sciences subjects are related to the legal research. So labor law problems, societal problems, family law problems, caste oriented problems, class oriented problems, all these were identified. Environmental issues, developmental issues, law and development, law and environment, law and workmen, law and women, law and child, law and uh, old age people, law and juvenile, criminal justice system. All these were identified for doing research only in post-1980 development. Simultaneously, we can understand the dynamic role played by the judicial process, whether it is the apex court, Supreme Court of India, until Manaka Gandhi, Supreme Court of India, of course, in its initial stage, it gave more value to the fundamental rights, which were considered as sacrosanct values, and property was considered one of the sacrosanct value. So property was protected. Liberty was not that much protected by the Supreme Court in the initial stage. So simultaneously, various amendments were brought to dilute the strict sense of the protection of property. So whether property is to be concentrated in few hands or property is to be redistributed. Article 39 B and C, prevention directive principle, prevention of concentration of economic power and material resources of redistribution. Then Jamindari abolition, various land reforms, abolition of privy purses, banks nationalization. All these were simultaneously done by the executive and legislature. Supreme Court and various high courts tried to protect the interest of the property. Then there was a constitutional amendment to remove right to property from fundamental right chapter. It was made as a mere fundamental constitutional right under Article 300A. So why I am discussing all these things? In order to understand what is the hypothesis in a legal research, first of all, we have to identify the research topic. So identification of the research problem is the first fundamental function of a good researcher. You may have 4 or 5 topics in your mind, but ultimately, after having weighed, after having examined the substantial scope of that particular research topic, you can identify one research topic to carry out the research. When I was a student, when I was a teacher, I participated in one refresher course where Professor Mitra, N.L. Mitra, while giving the lecture to us, gave a beautiful suggestion. You are not doing a research at a time on 4 or 5 topics. So you first settle down to your research topic, identification, and settle down to the research topic is the first function of any good researcher. It is also applicable to legal researcher. And because the knowledge is sciences are 2 types: natural sciences, where the experiment, that is what is, if any thing is observed through 5 senses of a human being, it is physical thinking. Whereas your natural, your any philosophical thinking, those are metaphysical thinking. Natural law was rejected by Jeremy Bentham as a metaphysical mist. So, but because while we implant the reason, so what is the reasonableness? So today, the entire jurisprudence is based upon reasonableness. If you want to understand the scope of dynamics of equality under Article 14, you have to go for reasonable classification. This classification, providing opportunity, equality, implementing at the stage of providing opportunities, distributional equality, and equality of result. So dynamics of equality is to be examined with the help of doctrine of reasonable classification. If you go to the protection of liberty, Article 19, freedoms. So government, state can impose restrictions. What type of restrictions state is permissible to permitted to impose restrictions? Only reasonable restrictions. By way of implanting reasonableness in imposing restrictions, Article 19 freedoms can be examined. The constitutional validity the sanctity of the protection of freedoms in the name of human rights, in the name of fundamental rights, is to be examined through reasonable restrictions. Then if you come to Article 21, law is not any draconian law. It should be just, fair, and reasonable. So the reasonableness plays an important role. It is brooding omnipresence everywhere in human life. So law is, after all, an instrument, a tool to help the human beings. Law is not a master. Law is a servant to help the people. All these are to be kept in mind by the sincere researcher. And researcher wants to do only on particular one topic. So if it is a natural science topic, hypothesis, experiment, and result, verification. But why we are having social science? Why social sciences are identified as a social science? Science is not merely verification of the fact. Sun rises in the east, earth moves around the sun. All these are proven facts. Day has 24 hours. If you go beyond that, for every year, one day, 24 hours can be extended to 365 days. These are all the scientific observations. Whereas social study are also understood as sciences. The reason is any systematic study is understood as science. So when we study, when we take up a research study, we have to understand that we are conducting a systematic study as far as possible. Thereby, the error can be minimized. So here, hypothesis. So thesis is the proven fact. Hypothesis, before proving, you identify a particular concept as hypothesis. Hypothesis may be several kinds. So sometimes a research can be started with null hypothesis also. Say, for example, you take any law university, you take any law school. Your hypothesis is so and so law school is very standard law school. It has research potential. The law school has adequate infrastructure. The law school has adequate facilities. Law school has research programs. Law school has good academic faculty. These were your hypotheses. So if you start critically examine with the facts available by way of observation through empirical study or case study method or your doctrinal method or your non-doctrinal approach, your research may lead that your hypothesis is proved valid, or sometimes your hypothesis may be proved or disproved. So that aspect is there. And from 1980 onwards, empirical studies, empirical research, non-doctrinal research, non-doctrinal study was also accepted in legal research. So legal research is nothing but social science research. That's why all social science research techniques are adopted. That's why as legal scholars, as legal researchers, as legal academicians, we also follow the tools developed by social scientists. The research methodology adopted by social sciences can also be squarely adopted by the legal researchers. So that's why Indian Law Institute identified. After that, you have several research programs, identify several research institutes. Say, for example, in order to study the labor law issues, labor problems, you have V.V. Giri National Labor Law Institute. Like that, you have different national level institutes to do research. TC is there, Tata Social Science Research Institute, and you have various methods. So that's why you have to take good researchers. That's why from 1980 onwards only we have the present day research. Basically, we dependent upon the social research methodology adopted by the other, by an economist, by a political scientist, by a historian. That's why comparative method, thereby conceptual method and comparative analysis, and the different types of methods were adopted. One researcher may adopt only one method or simultaneously different methods. And some research may adopt only doctrinal method. So, second, basing upon secondary sources, library, judicial judgments, legislations, textbooks, international conventions, these are all secondary sources. Basing upon the research reports submitted by the previous researchers. Then some legal researchers may adopt non-doctrinal method, empirical study. As I just mentioned, the empirical legal research techniques are also the empirical research, social science research techniques. That's why any research scholar can refer EPW, Economic and Political Weekly, for 50 years, for 30 years, for 20 years. You can get many more empirical studies relating to law also. So, say for example, if you take reservations, that's why when Mandal Commission was appointed, one sociologist, M.N. Srinivas, was appointed to study the backwardness, social backwardness, economic backwardness, educational backwardness, and basing upon the Mandal Commission report, when 27% reservations at national level were implemented. Prior to that, Jawaharlal Nehru government appointed one commission because there was no unanimous opinion. Central government did not take up that task, and central government allowed the various state governments to implement their own reservation policies basing upon the state commissions. So, Channapareddy Commission and all these are there. When a particular person wants to do research on reservations, protective discrimination, or compensatory discrimination, or affirmative action, he may compare the reservation issues in India and elsewhere in America or in England, and on what basis these type of things are there. The comparative approach may help. Say, for example, when we brought Constitution of India, our constitutional makers have this drafting committee, and Sir B.N. Rao, Benagal Narasimha Rao, was appointed as a constitutional advisor. On behalf of constitutional drafting committee, Sir B.N. Rao visited several countries, and he got the experiences of those legal experts there. So those were brought to India and referred to drafting committee. For example, when he met Justice Frankfurter advised Sir B.N. Rao, because due process clause under American Constitution, American judges were interfering more and more in executive process and legislative process. So better not to take judicial process. Then he suggested, B.N. Rao, instead of due process, you took procedure established by law from Japanese Constitution. That's why Article 21, no person shall be deprived of his life or personal liberty except the procedure established by law. Whereas under American Constitution, no person shall be deprived of his life, liberty, and property except due process. But that's why it took some almost 28 years to Indian Supreme Court to came out of the clutches of procedure established by law. Any type of procedure was followed. That's why Justice Krishna made a famous observation in Sunil Batra too. That says Delhi administration. No, it is true that there is no due process clause or Seventh Amendment or Fourth Amendment under Indian Constitution, but the result is the same after Maneka Gandhi. This was possible because of the research. So when a researcher has studied something and he developed some knowledge, then basing upon some knowledge, he has some dissatisfaction with the existing knowledge. Then he has to pursue for new knowledges. So he identifies the problems so that he can conduct some research so that his research may provide some solutions. So that is the aspect, that is the purpose of research. That's why the objectives of the study, the identification of the research problem, the research design before hypothesis is also very, very important. Research design includes your budget, your time frame, your value of your research, your budgetary allocation, how you are getting the funds, how you are spending, how you are pursuing. That's why UGC encourages this JRF, Junior Research Fellow, Senior Research Fellow, to the research scholars to encourage the research in Indian context. So that is one thing. So as far as my topic is hypothesis testing, after having conducted the research, so particularly this is a limitation of the study, empirical approach. So when you study empirical approach, what are the research methodology? What is the research methodology? What are the research methodological technique? So case study method is there, interview method is there, then schedule method is there for the people who are not having any literate, those who are illiterate, those who cannot understand the questionnaire. A schedule can be separately prepared, and you have case study method. So using different techniques, you can conduct your research. Then after collection of data, you have to, your job is to analysis of the data, to interpretation of the data, construction of the data, so that there you have to use your statistical methods. You may have pie diagram, these bar diagrams and scaling techniques in order to assess this thing. And you have to compare, you may sampling method particularly when there are, say for example, 50 lakh people or 60 lakh people in a particular district. You want to do an empirical study in a particular district. You may take, you may not go all the 50 lakh people. Your sampling method, a random sample and selective sample, different methods of sampling is there. So out of that you can classify. So your sample method should include all the representatives. Say for example, you may have a problem of uh, family law, a diverse family, or family court issue. So then you have to classify advocates, judicial officers, general public, and male and female, married women, unmarried women, divorced men, their problems, all if it's a senior citizen problem. That's why, depending upon your research problem, you have to identify the research method. Sometimes you have to take 2 or 3 methods. Sometimes you have to apply both doctrinal and non-doctrinal method. You may have historical method. You may have comparative method. So all these will help you. That's why researcher should have unbiased one. If any researcher then participative research, non-participative research. So you may have a research problem. that there is a menace of ganjai or whatever it may be, drugs and others. A researcher need not be a participative research. A researcher may adopt a non-participative research. So a researcher adopts a problem of prostitution, a problem of any developmental issue or poverty issues. So for all these, you have to take this thing. So how far we can understand and identify the research problems as far as legal research is concerned. So that's why our research at present is a politico-legal study, a socio-legal study, an economic legal study. So the economic analysis of law and sociology of law, legal sociology, these are the various methods and studies. The scope of your research is to be identified after having known all these methods. I already told you what is the research problem, what is the research design, what is the research method, what is the research process, and how you how to write a research report. So the testing of hypothesis. So as you know, when I was a teacher participating in legal research methodology classes, one social scientist, an academic professor, used to give a lecture on methodology. He gave two examples. In Pune, there were communal riots on one day. Some people were died. So the opinion for the cause of that communal riots was something else. There was all of a sudden outbreak of a dispute between Muslims and Hindus and something else. But the research revealed, because of Balagangadhar Tilak's speech in one temple, these communal rights were instigated. The research topic, the name of the research is the date on which the communal rights were occurred. He wrote only some 20 to 25 pages report. No Indian university accepted. One foreign university gave the research degree. Another example he cited, still I remember. Aurangzeb has to conduct innovations and everything, wars with everything. And he was famous for anti-Hindu culture and other things, jihad and conversions and all this. In one day, his entire military was staying in one place. The wife of one Hindu soldier in his military went to visit one Vinayaka temple, Lord Ganesh temple, in one underground. The priest of the temple raped her and killed. This news was burst. Aurangzeb ordered the demolition of the temple. These were the rare incidents. Generally, what was the opinion about Aurangzeb? Aurangzeb is anti-Hindu. When we come to compare Akbar, has Paramata Sahana, so religious tolerance and all these qualities we attribute King Akbar. Aurangzeb, we have another different perception. But the real reason for that is the killing of the wife of one Hindu soldier in his military. So that is what is research. So researcher should be unbiased. If you have a feeling that Aurangzeb has these type of things, your research report, your research result has the partiality. So that's why the good quality, even we are talking in legal research, the good quality of an arbitrator, a good quality of a mediator is he should maintain equilibrium. the researcher, the good researcher should have the equilibrium. That's why one research may be started with null hypothesis. So, he has no any hypothesis. So his research leads to continue that particular proving or disproving one particular thing. So my suggestion is, my suggestion to all young research scholars, that you should have to develop an unbiased equilibrium aptitude, research aptitude, to have a good research results. That is my personal experience after having completed my research in the early stage and started giving supervision to various research scholars. So when I was a student of LLM, I used to get the lectures of Professor Bhandarkar, a sociology professor who used to come every Wednesday to our department to give a lecture on research methodology for LLM students. So he wrote a book, Wilkinson and Bhandarkar. Wilkinson is an English sociologist. Bhandarkar is Nagpur-based sociology professor. So he gave a suggestion to the LLM scholars. So each scholar should know the topics given to all the other scholars. When you have 40 to 50 research topics given to different people, you will, knowing all the research topics of all the research scholars, you will develop a research aptitude. Now we have Sodh Why there is Sodh available in the website? The young research scholar, the beginner, should know what type of literature available regarding research reports. Different universities' research reports are available. So where you can review the literature and you can have identifying your own research problems, which are further formulated into the hypothesis, maybe one hypothesis or two hypotheses or three hypotheses. Then you start your research, then the results of your research, major research findings, with the help of major research findings, you will test your hypothesis. So testing of the hypothesis based upon the research results can be the acquired your knowledge. So friends, I am very happy that I am sharing my experiences with the research in general and legal research in particular. So now we have various avenues, opportunities to the legal fraternity, maybe law student, a 5-year law student, a 3-year law student, or LLM scholar, or PhD scholar, or an advocate, or judicial officer. So that's why we have judicial academies were established throughout the country. Every district has judicial academy. Every state has judicial academy. So unless the knowledge is fresh, the law keeps on changing with the changing needs of the society. You have to understand the needs of the society, changing needs of the society, and you have to understand what is law and what is the lacuna in the law. How can you have? Say, for example, now we are law commission is striving to make a uniform model uniform civil code. So for which it has its own course of action, consulting experts and taking opinions, draft this thing. So what was the earlier status of different religious communities? What was the status of Hindu women? What was the status of Muslim women? What was the status of Christian women? So how we can ensure the improvement of the status? So for my 30 years experience as a personal law teacher, family law teacher, improving the status of women, status of wife, status of sister, status of daughter, status of mother is the improvement of women in India, which may lead to various aspects. How can we strengthen the empowerment of women? We are talking about the reservations to women. Now uh, for several years it was pending. When the bill was introduced, attempts were made. Some MPs took the bill from the hands of the law minister, and it was torn into pieces. So at that time, Sharad Yadav and all these people highly objected the implementation of 30% reservations. Their reason for non-cooperating the implementation of 30% was, if 30% reservation was given, I am using the words quoted by Sharad Yadav in Rajya Sabha, bobbed head, modern woman will come. In the name of women reservation, the super class, high class women will snatch away the benefits. So we want reservations and all these things. From then onwards, the various attempts are there. Now we are hearing that the day will come for implementation. So all the problems, all the issues relating to different stakeholders of that particular issue be addressed now. So otherwise, it will be corrected at a later stage. So implementation of 30% reservations at Panchayati Raj level, at local bodies, was successful. Now in Andhra Pradesh, I had an experience. So for the last 4 or 5 general elections in local bodies, women representation was there. There was a classification: general women, backward class women, SC women, ST women. They were being empowered. Now there was no second thought about giving reservations. So that's why legal researcher particularly should have to take note of all these issues. That's why I have a strong feeling a lawyer, a judge, a law teacher, a law student, a legal researcher be benefited more. His potentiality will be increased more when he or she can acquire, can have the first hand understanding about social structure, political structure, and economic structure. Then only we can understand the legal structure which will be useful for transforming the society. We all know Karl Marx, what Karl Marx famous statement? Law is a weapon in the hands of the ruling class to perpetuate their power. His issue is, the problem is how to quickly change the uh, proletariat dictatorship. He wanted the working class government. So of course, all we know. So that's why if you go to history, we know all these things from different periods, different social scientists, different political scientists, different jurists, different philosophers. Actually, we know until 19th century, law was not studied as a separate subject. Law was studied along with philosophy. Law was studied along with religion. Law was studied along with morals, political science, economics. And the person who was expert in philosophy, who was expert in morals, who was expert in ethics, were taken into considered as a judicial officer, an advocate. You know the famous tale of Socrates in 3rd century BC, particularly. Uh, the main allegation against him, he was the main allegation was, Socrates was spoiling the youth of the day. and challenging the dogmas of the religion. 500 elderly citizens in Athens, because in those days, Greek city-state, every city itself is an independent republic. The same corresponding correlative comparison in Mahajanapadas, 16 Mahajanapadas, out of which Magadha was ascended as a mighty authoritarian form of government. Until Magadhan ascendancy, 16 Mahajanapadas were there in India, in northern India. So all have republican form of governments where the king was elected. Samiti Sabha were there. The corresponding period was in Greek society. We have Greek city-states. Each state itself is an independent, each city itself is an independent state. Socrates was prosecuted. 500 judges tried the case. 270 people came to the conclusion Socrates committed the offense. 230 people understood Socrates did not commit any offense. Socrates made a comment in those days. If 20 people change the opinion, I might have been saved. But when his disciples wanted him to escape, he did not accept. So far now, this political state protected me as a citizen. It gave me protection. When it orders me to be killed, I should surrender to the state. That's why Socrates is famous. The comparative trial, Mahatma Gandhi. And Mahatma Gandhi was prosecuted for the offense of sedition. The then British judge asked him, don't you know, being the lawyer, violating the law of the land attracts the punishment? Mahatma Gandhi's reply still is relevant in the judicial process. He replied the judge, yes, I know. But when the existing law is against my conscience, against my intuition, against my reason, I need not follow it. At the same time, being a law-abiding citizen, I surrender myself to the punishment. That is the greatness of Socrates and Mahatma Gandhi. So the researcher has to know the philosophy, the economics, the historical background, the political science, everything at a higher learning stage. All the knowledges are one and same. Unless you are a good economist, you cannot become a good political scientist. Unless you are a good historian, you cannot understand the present day society. The past history is the past history. History is the past sociology, whereas sociology is the present history. So, as a legal researcher, first of all, you should develop a pragmatic approach to understand all these fundamental core values of the knowledge. Then only one will be successful. Thank you very much for giving me this opportunity. I am sorry
Sir,
I have any formative approach of giving lecture, but
no, sir.
I am very thankful to the organizers. Actually, tomorrow I have selections in my university.
Yeah,
So
yeah, yeah.
even then, because I should accept when an academic challenge is posed to me, being an academician, I should accept any challenge. Thank you very much. I wish the organizers and the research scholars all the
Sir, we
best.
have,
Thank you
sir,
very
we
much,
have,
sir. Thank you very much.
sir, we have one or two questions from the student.
Yeah,
Uh,
yeah.
the first question from the LLM student, that how does hypothesis testing enhance the objectivity and reliability of the legal research compared to the traditional doctrinal method? This is the question
Oh,
from one of the LLM students, sir.
yes, yes. Uh, any method, whether it is doctrinal or non-doctrinal or empirical study, identification of the research problem and objectives of the study may have. That's why I told you simply, the researcher should have an unbiased mind. and he should have an equilibrium. So if he has a pre-notion about a particular thing, his research hypothesis will not be perfect one. So he has to accept the result, whether his hypothesis may be proved through his research, or it may be disproved. So with a free and fair mind, researcher has to start his research from the stage of hypothesis. That is my opinion.
Sir, we will take just last one more question. One
Yes.
student of LLM has asked this: to what extent does the integration of empirical hypothesis testing transforms the legal research into the more evidence-based discipline in the modern jurisprudence?
Yeah, empirical. The results are very useful. Na? That's why we are conducting the research.
Excellent.
So when a good research project is there, say for example, uh, environmental capacity building research project was given by World Bank to Indian national law universities in 2000 to 2010. So what is the object of that research project? So how environmental capacity building is to be built up in India, so that the various issues relating to environment has to be identified. So, say for example, because of the production of more production of environment may lead to the what we say underdevelopment. If you have more development, more environmental destruction. If you want to go to environmental protection, development may not be taken up. So, as a balance, sustainable development was developed. But when sustainability is not possible, as you know, Ronald Dworkin taking rights seriously. So, at a particular given time, some rights are strong rights, some rights are weak rights. Until recent past, right to privacy was a weak right. Right to life was a strong right. After Kuppuswamy and other judgments, right to privacy was also understood as a strong right. So here, uh, sociological jurisprudence says that society is with full of conflicting interests. Law is a balance among the conflicting interests. To that extent, okay. Balancing harmonious construction between fundamental rights and directive principles and individual freedom and societal interest. There should reasonable restriction may be a balance between individual liberty and societal interest. But if balance is not possible, answer is provided by Ronald Dworkin. What is strong right? What is weak right? At a particular given time, the society has to decide this is strong right, this is weak right. Say, for example, in some aspects, right to environment may be strong right. There you have to promote right to environment at the cost of development. In some aspects, development is more strong right than environment. Narmada Dam, where Supreme Court permitted the construction of dam. In the open court, Arundhati Rai made an announcement. Our judges were sold, for which she was punished under contempt of the court for 1 week or so. The criticism was also there uh, for punishment. So here my point is there. Say for example, uh, uh, X versus Y, comma Z hospital case. Just now, wait. Uh, sir, I will call you back. Sir, okay, sir. Sir, namaste అండి. Harish Kumar. So X versus Y, comma Z hospital case. The Supreme Court did not want to disclose the names. X is a HIV infected patient. Y is a woman who entered into a betrothal with the X. On knowing the information that X is an HIV infected patient, she cancelled the marriage. So for contractual performance, he came to Consumer Forum, then Supreme Court ultimately. Here the debate is, X has a right to marry and establish family, procreate children is the one of the Universal Declaration of Human Rights. His right is to be implemented. Why has corresponding right in such way? Why has not only these rights, right to marry, establish family, procreate children, and also a healthy marital life? When there is a conflict between right to marry and right to healthy married life, right to healthy married life is a strong right. So your research hypothesis, all these are, so you may say, right to marry is the strong right to be protected, maybe your hypothesis. After having conducted research, your hypothesis may be proved wrong with these type of cases. So what is to be promoted, what is to be ignored or sacrificed depends upon the individual. That's why if you take the this issue regarding fundamental rights and directive principles, the first view was a very traditional view. When there was a conflict because fundamental rights are enforceable, directives are non-enforceable, fundamental rights are to be promoted. Muhammad Hanafi Qureshi and even Champakon Dorai Rajan versus State of Madras. After that, particularly 39B and 31C was created. In order to implement 39B and C, 1931 can go back, a legislation can be brought, and 31C was challenged in Keshavananda, which was permitted to some extent. Then Madam Gandhi again amended through 42nd Constitutional Amendment in the place of 39B and C in order to implement all the directives. If any fundamental right 1931 were affected, even then it was valid. It was challenged in Minerva Mills. And Minerva Mills, two opinions were exhibited, a 4-1 judgment. Justice Y.V. Chandrachud made a comment, balance should be maintained between these two, and unnecessary giving importance to directive should be discarded. So the amended 31C was struck down as unconstitutional. Original 31C accepted. At the same time, in the same judgment, minority judge Justice P.N. Bhagavati gave a minority judgment. Fundamental rights are individual rights. Directives are social rights. When there is a conflict, let the society develop at the cost of individual. But that is a minority. So that's why different hypotheses, different researches, one research report finding may not be equal to another research finding. I will try to end my discussion. The one English sociologist in 18th century conducted a research in Telangana area regarding one village. His research topic is village. So he was a prominent sociology professor. After 100 years, Professor C. Lakshmana of Osmania University in 1980 conducted the research on the same village in order to understand the social transformation in the village. How many families are there, how the development was there. So his research, 100 years comparison of the same village. So his research revealed various factors for the development. So that's why regarding your caste class convergence also, Professor M.N. Srinivas suggested this particular thing, particularly imitation of the upper caste practices by the lower caste practices used to be witnessed through his research. So all these aspects are there. That's why depending upon your hypothesis, sometimes your hypothesis is strong, scientific, fundamental one. It may be proved with your research. But being a neutral, unbiased researcher, you should have the open mind. You should not bother about the research result. You conduct the research on your own. That is my suggestion.
Now I will
Sir.
tell Dr. Bijal Zaveri, madam, academic associate dean from doctoral studies, to give the vote of thanks, and then we will wind up this session.
Okay. So, first of all, sir, thank you so much. You have shared various examples, which is very need for the today's generation to understand that how to measure the credibility, reliability in the hypothesis testing of legal research. And whatever the last example also, sir, you have shared, it was a very wonderful, because some of the things are very general, but to make it in a legal research form, it is a quite difficult to understand. So it was a great insights for all the scholars, though scholars from the law background or scholars from the other background, the ultimate the concept remained the same for the hypothesis testing for any type of research. So on behalf of Parul University Doctoral Studies and Research and Faculty of Law, jointly we are giving special thanks to Dr. Professor Surya Rao sir for providing such a valuable sessions to our research scholar students. Thank you, sir, once again, and we would like to make such type of sessions for our researcher in future. Thank you so much.
Thank you very much. Thank you very
Thank
much,
you,
madam.
thank you,
Thank you,
thank you, sir. Thank you.
thank you,
We are
thank
closing the session. Thank you,
you.
Vijay
Yeah,
madam.
thank
Thank
you,
you, Ashok Kumar sir.
thank you, thank you.
Thanks a lot. Thanks.
Why, Naresh?
Yes, we can close.